One.
This Honorable Court of Tennessee is now in session.
Good afternoon, gentlemen, and welcome to the Court of Appeals. First of all, I'd like to thank you for your participation in this oral argument via Zoom. It is the best way that we can keep everybody safe and continue to make the wheels turn and cases progress. So we appreciate you and your clients agreeing to participate. Both of you are experienced practitioners, so you know what the procedures and the rules are. Just want to remind you that we will be participating today, or that this argument will be conducted today simply in the same manner as if we were all in the courtroom. So the same rules and procedures and protocols will follow, which essentially means each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time, you'll receive that time after the appellee's argument. Before we start, though, I'd like to take a moment and introduce our panel today. It's Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Kraft, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Nashville, Tennessee Ventures Incorporated versus Norma Elizabeth McGill.
Thank you. And we will hear from the appellant.
May it please the court, appellant plaintiff appeals from the trial court's decision granting defendant's motion to dismiss for failure to state a claim. Plaintiff respectfully requests that this court...
Mr. Barrett, before we start, you need to introduce yourself since this is being recorded. We know who you are and we can see who you are, but unless you introduce yourself on the tape, we don't know. So.
Yes, Your Honor. This is Chris Barrett, appearing on behalf of plaintiff appellant in this case, Chris Barrett from Baker Donaldson.
Thank you, sir. Appreciate it. You may proceed.
Plaintiff respectfully requests that this court reverse the trial court's decision granting defendant's motion to dismiss and remand this case back to the trial court. The trial court's decision should be reversed because each count of plaintiff's complaint states a claim. Starting with plaintiff's second count, the breach of duty of loyalty. Plaintiff sufficiently stated a claim for breach of the duty of loyalty. Defendant's only argument on this claim is that plaintiff did not allege defendant was employed by plaintiff. However, plaintiff expressly alleges defendant was employed by plaintiff in paragraph 10 of the complaint and expressly references defendant's employment with plaintiff in paragraph 11. Plaintiff also alleged defendant resigned from her employment with plaintiff in paragraph 37. Plaintiff further alleged additional facts supporting the existence of an employer-employee relationship as outlined in plaintiff's opening brief on pages 19 and 20. In ruling on a Rule 12-026 motion, the trial court must liberally construe the pleading, presume all factual allegations as true, and draw all reasonable inferences in favor of the complainant. Plaintiff has sufficiently alleged defendant was plaintiff's employee. In the briefing before the trial court and this court, defendant has never once disputed she was employed by plaintiff and acknowledged in her briefing on the motion to dismiss that she did sign the contract. And of course, defendant cannot in good faith dispute the fact that she was plaintiff's employee because she filed and maintains an FLSA claim against the plaintiff in federal court. There can be no doubt that plaintiff has received fair notice of plaintiff's, defendant has received fair notice of plaintiff's claims against her. Defendant attempts to circumvent those factual allegations that must be presumed as true in the context of a motion to dismiss by focusing on the use of the word thereafter in paragraph 10 of the complaint. Defendant argues that the use of thereafter in paragraph 10 somehow makes the plaintiff's allegations regarding defendant's employment dependent on whether the contract is enforceable by plaintiff against defendant. This argument also is without merit. Thereafter is merely a statement as to time. Defendant signed the contract, and after that point in time, she began her employment with plaintiff, not because she signed the contract, but because she performed work at the direction of plaintiff and was compensated for that work.
Let me ask you, Mr. Barrett, you say not because she signed the contract. What was the purpose of attaching the contract to your complaint, especially in light of the fact that your client is not named in the contract itself?
Your Honor, we do have a breach of contract claim, so we are moving under the contract, and that is why it was it's attached. On the breach of duty of loyalty claim, our position is that whether or not the contract is enforceable does not impact that claim, and whether or not those allegations that defendant was our employee, those allegations will stand regardless of whether or not the contract was enforceable. But the direct
if you have a breach of contract claim, first you've got to have a contract with the party, don't you?
That's right, Your Honor. Yes.
But your client is not named in the contract. There's not an entity named in the contract.
Yes, Your Honor.
Do I have that right or not? I'm just.
You do have that correct, Your Honor. And our argument on the breach of contract claim is that contract can be reformed because it's merely a mutual mistake as to whether or not, as to the name that appears in that contract. The entity in that contract is a former entity that was involved in the owners of our current company. They had that form contract with them, and they put it in front of the defendant here, and she signed the contract, but she never had any relationship with that former entity. The names of those two entities are very similar. We would say it's akin to a situation where, the name of the entity is LLC and someone puts incorporated on the end of the contract. It's a mutual mistake that can be reformed under Tennessee and Florida law, because it's just, there's a meeting of the minds that she was going to be employed by this entity doing this job, and we merely just got the wrong name in the contract.
Okay.
But again, on the breach of duty of loyalty claim, our argument is that claim stands whether or not the contract is enforceable. And that's because we have alleged that she's our employee. We have those allegations in there, and we would submit that if the contract is not enforceable, then that contract, if it's going to be construed as an allegation, cannot override our express allegations that she was our employee, because it's not enforceable. It doesn't change the contractual relationship or the employment relationship between the parties. The contract does nothing to impact the plaintiff's clear allegations that this defendant was employed by this plaintiff. Defendant does not raise any other issues regarding plaintiff's breach of the duty of loyalty claim. Defendant owed plaintiff a duty, as all Tennessee employees do, regardless of the contract, breached that duty, and plaintiff suffered damages as a result. Therefore, plaintiff's breach of the duty of loyalty claim is well pled. Turning to plaintiff's first count, which is the breach of contract claim, a motion to dismiss for failure to state a claim is properly granted only where the claimant can prove no set of facts that will entitle it to relief. Here, there are facts that can be proven that would entitle plaintiff to relief. Simply because a contract inaccurately listed Helping Timeshare Owners LLC instead of plaintiff's DBA Help for Timeshare Owners does not render the contract unenforceable. This contract can be reformed because plaintiff can present evidence that despite the error in naming the parties to the contract, both plaintiff and defendant understood that this contract applied to defendant's employment with plaintiff. Plaintiff can present evidence that there was a meeting of the minds between plaintiff and defendant where both parties understood defendant would be employed by plaintiff. Turning to plaintiff's third count, civil conspiracy. The trial court dismissed plaintiff's civil conspiracy claim because it ruled plaintiff has not sufficiently alleged an underlying wrongful act, given the trial court's dismissal of the breach of the duty of loyalty claim. Likewise, defendant argues on appeal that plaintiff did not appropriately plead an underlying tort. As noted above, plaintiff asserts that it did state a claim for breach of the duty of loyalty. If this court agrees, this court should likewise find that plaintiff states a claim for civil conspiracy. Accordingly, plaintiff appellant respectfully requests that this court reverse the trial court's decision granting defendant's motion to dismiss and remand this case back to the trial court. Appellant plaintiff also respectfully requests that this court reverse the trial court's decision denying plaintiff's motion to alter or amend. Based on the arguments outlined above, plaintiff asserts that the trial court made clear errors of law in granting defendant's motion to dismiss. Specifically, the trial court's ruling that plaintiff has not alleged a standalone breach of the duty of loyalty claim is a clear error of law because every employee in Tennessee owes his or her employer a duty of loyalty, irrespective of any contractual relations.
Is that true if Ms. McGill was an independent contractor as opposed to an employee, Mr. Barrett?
Well, Your Honor, to answer your question, I think the law is unsettled in Tennessee on that point. We have submitted competing cases on that. A plaintiff has submitted the Biggers case, in which I think the court in Biggers articulates a very clear common sense rule that an an independent contractor cannot take actions that are adverse to the contract to the company in the scope of what their employment is. And that makes sense, is that an employer can't come in, independent contractor can't come into a business, start doing work, and then take actions that are, I think one court described it as the actions of a traitor and do something to undermine the business. Now, that doesn't mean that the independent contractor, once the contractor and the engagement is over, can't go out and compete against the employer. Does not go that far.
But that case doesn't answer the question of whether or not an independent contractor has a duty of loyalty, did it? It just says that an employer can terminate an independent contractor for certain conduct that they consider to be a breach. But the case doesn't specifically hold that in Tennessee, an independent contractor has a duty of loyalty. Does it, Mr. Barrett?
I'm not sure that explicitly holds that, Your Honor. I think it makes a statement as to a duty that sounds a lot like a duty of loyalty, but you're correct. It does not explicitly hold that in Tennessee there's a duty of loyalty. I would distinguish.
Let me ask you one further question. If in fact you have an enforceable contract, and the contract here has a choice of law provision, and it also has an arbitration provision, I mean, why are you here if there's an arbitration provision?
Yes, Your Honor. Under Florida law, an arbitration provision can be waived, and so, the direct answer I think to that is that the plaintiff would prefer to be in state court in Tennessee, and the defendant has made no effort to remove this case to arbitration or move to compel arbitration. So that's why we're here, Your Honor. I know the rule in Tennessee is it's mandatory to compel arbitration, but that's not the rule in Florida, as I understand the law. I would make one statement distinguishing the case cited by defendant on the independent contractor issue. In that decision, the court's talking about a fiduciary duty, a higher fiduciary duty that's owed by corporate executives, and there is case law in the state of Tennessee and in the federal court in interpreting Tennessee state law that says that there's a confusion about whether or not a duty of loyalty, some courts have called it a fiduciary duty of loyalty, but it's not really a fiduciary duty, it's just a duty of loyalty. So I think that case cited there is talking about fiduciary duties rather than a duty of loyalty, which is something different. Thank you.
Okay.
All right, thank you. We will now hear from the appellee.
May it please the court, Your Honors, I'm Chad Jackson here today on behalf of the appellee, Norma Elizabeth McGill. This court should affirm the dismissal by the trial court of the appellant's complaint for failure to state a claim upon which relief can be granted, and should also affirm the trial court's denial of the appellant's motion to alter or amend judgment for two reasons. First, appellant's complaint is wholly dependent upon a document that's attached thereto between Ms. McGill and a non-party entity that has no involvement in this case. And second, despite ample opportunity and time, appellants made no efforts at the trial court to cure the defects of its complaint. At the outset, Your Honors, it appears that the appellant and appellee can agree on one thing. At the hearing on its motion to alter or amend, the appellant through counsel stated, Ms. McGill, quote, had nothing to do with the Florida company, end quote. The Florida company being the non-party entity Helping Timeshare Owners, LLC. That, I would note, is contrary to counsel's argument today about there being some way to show Ms. McGill if I followed the argument correctly, signed this contract with a non-party entity, but somehow knew she was being employed by plaintiff, none of which is alleged in the complaint. But as counsel noted at that hearing, Ms. McGill had nothing to do with this non-party entity. Despite that, the appellant incorporated by reference and attached to the complaint this contract, purported contract between Ms. McGill and Helping Timeshare Owners, LLC. As Judge Armstrong noted earlier, our plaintiff here, Nashville, Tennessee Ventures Incorporated, doing business as Help, the number 4, Timeshare Owners, appears nowhere in the purported contract. Not only that, Helping Timeshare Owners, LLC from the contract appears nowhere in the complaint. And I would respectfully disagree with counsel's argument today that those are somehow the same company without an LLC. One is Helping
Mr.
Timeshare
Jackson,
Owners.
did Mr. Barrett make that argument at the trial court level? The connection between the non-entity and the plaintiff here?
Your Honor, at first, the appellant's position at the trial court level was that they could somehow show a nexus between the two companies. Then at the hearing on the motion to alter or amend judgment, the appellant's position was that they were foregoing the contract claim, breach of contract claim. Indeed, their counsel said, quote, "We understand that that's a problematic claim for a lot of reasons," end quote. So to answer your question, Your Honor, they've argued both. And what they're arguing today is inconsistent with the construction of the complaint. Despite our plaintiff, and before I move on, I would note that any assertion that one company is simply a restatement of the other and they're just simply missing an LLC is without foundation or merit. On the one hand, in the purported contract, we have Helping Timeshare Owners, LLC, its own limited liability company, presumably. In our complaint, in the style, it's Nashville, Tennessee Ventures Incorporated, completely different, doing business as Help with the number 4 Timeshare Owners. It's not its own LLC. It's a completely different name, contains a number that's not contained in the entity in the contract. Despite these differences, the plaintiff, the appellant, decided to quote and cite a portion of that purported agreement in paragraph 8 of the complaint. And then in paragraph 9 said thereafter, as Mr. Barrett noted, thereafter, Ms. McGill was employed. It's a modifier, one of the other. And that's another position, another situation where the appellant has given different explanations respectfully to the appellant and candidly with the court. At first saying that Ms. McGill signed the contract and then after that became an employee somehow of plaintiff, even though that's not alleged as to any nexus between the parties in the complaint, but then arguing at the motion to alter or amend that these are inconsistencies in its own complaint that it drafted that should somehow not be read against each other. In any event, this purported contract with a non-party entity is the underpinning and foundation of the entire complaint. After citing it, incorporating it, and referencing it in the factual allegations of the complaint, appellant then realleged and incorporated each prior paragraph, including those factual allegations and Exhibit A, into each and every count. The trial court succinctly and accurately noted that the complaint is clearly premised upon the execution of this contract between Ms. McGill and this other entity. That was stated at the conclusion of the hearing on the motion to alter or amend. As I mentioned a moment ago, at that hearing, the plaintiff forewent any argument on the breach of contract claim, said that that was problematic for a number of reasons. It did not even argue it at the motion to alter or amend. Before this court, it's included as the third argument in the appellant's brief instead of the primary argument, despite the sequential numbering of the counts. And I suggest to this court that if count 1 fails, so do count 2 and 3, because again, everything is reincorporated, realleged into one and another. Plaintiff did not, the appellant did not plead the counts separately, did not plead them in the alternative, which certainly it could have done, of course. The appellant has spent a quite a bit of effort in the trial court and in the brief here in discussing the independent contractor versus employee situation. To touch upon that briefly, I suggest that this court need not reach that decision or determination because whether an employee or an independent contractor, per the allegations of the complaint, it would have been for a non-party entity, not for our plaintiff. But if the court disagrees, I would request that the court look at the plain language of the document that the appellant attached to its complaint. Paragraph 3 says employment classification. You shall be a full-time independent contractor and shall not be entitled to benefits except as specifically outlined herein. Again, you shall be a full-time independent contractor. Paragraph 5, though titled at-will employment, states in the second sentence, this agreement is intended to be and shall be deemed an at-will independent contractor agreement and does not constitute a guarantee of continuing. The document itself, as alleged by plaintiff, says this is an independent contractor agreement, and the appellant has noted that, of course, for purposes of a Rule 12 motion and this appeal, the court must take as true the factual allegations of the complaint. That's all factual allegations of the complaint, including those incorporated by reference and attached to the complaint by the appellant. The independent contractor language.
Does it matter that the contract was not signed by that entity named in the contract or by a representative of the appellant?
Your Honor, I believe it further shows a disconnect between Ms. McGill and the contract itself in that no one from the appellant signed it, and there are no allegations in the complaint that anyone from the appellant was even present or signed it. The mere fact of it not being signed, Your Honor, we are not hanging our hat on as an argument, but certainly I believe it to be instructive to the court that no one from the appellant signed the document. That would at least give some nexus as between the appellant and the non-party entity named in the contract, whereas we currently have no nexus between the two. I cite the independent contractor language in the purported contract because, as noted in the briefs, Pinehurst Limited versus Jarrett, a decision from this court in 1991 tells us that an independent contractor is not an agent with fiduciary duties. I would disagree with counsel's reading of that decision about it only pertaining to officers or those with some sort of heightened duty. The duty of loyalty is a fiduciary duty, and we know that. These cases are not cited in the brief, but I'll be glad to provide them. Knott's Wholesale Foods versus Asbell, Azbell, an unreported case from this court in 1990.
Mr. Jackson, if you're going to rely on things you haven't cited, you need to provide a supplemental authority to the court and be sure to copy counsel with it.
Yes, Your Honor. And this is in response to counsel's statement a moment ago about there being that the duty of loyalty is not a fiduciary duty. So this is a rebuttal to that, and I'll be glad to do that, Your Honor. Knott's Wholesale Foods versus Asbell, unreported decision by this court in 1996. And EFRID versus Clinic of Plastic and Reconstructive Surgery, Court of Appeals decision from 2003. In both instances, the claimant was an employee and the court characterized the duty of loyalty as a fiduciary duty. That circles us back around to Pinehurst versus Jarrett, which tells us that an independent contractor is not an agent with fiduciary duties. To mention briefly the Biggers versus Transportation Services, upon which the appellant so heavily relies, there the court held that an employer had good cause to terminate an independent contractor's contract based on the performance of his duties. Obviously, each contract is different, and presumably that contract is different than ours. I believe more instructive to the court are the circumstances in which the court made that decision, that being a termination of a contract. There are other cases cited therein that follow the same fact pattern, where the question before the court is whether good cause exists to terminate a contract. Again, I suggest to this court that it need not reach that decision because of the inclusion of the contract with the non-party entity. But in any event, it appears that both the appellant and the appellee agree that should count 2 fail, the breach of the duty of loyalty, so does count 3 of civil conspiracy, because it would need the underlying tort alleged in count 2. Despite the issues with the complaint, the incongruencies between the contract attached thereto and the allegations therein, the appellant took no action to remedy those, even after the appellee filed its motion to dismiss for failure to state a claim. After filing the complaint on March 11th of 2020, the appellant then filed an order of substitution to correct its own name on March 25th of 2020 without including helping timeshare owners, the non-party entity, in the style, and without doing anything in the body of the complaint to allege any nexus between itself and the non-party entity. Indeed, appellant has cited no cases where there was some sort of ability of a party to enforce a contract of a non-party entity absent a subsidiary parent company situation or something of the like that has not been alleged here. Nearly 2 months after filing the complaint, we had the hearing on the appellee's motion to dismiss, again, with no action by the appellant to correct or cure the deficiencies of the complaint. 18 days passed between the appellee's filing of the motion to dismiss and the hearing on the motion to dismiss. Again, nothing being done by the appellant. Indeed, the first request by the appellant to amend the complaint was orally immediately following dismissal, immediately following the trial court's announcement that it was granting the Rule 12 motion to dismiss. Of course, then judgment had been rendered. Though appellant still has not made any formal attempt to amend the complaint, it did attach to its motion to alter or amend a draft first amended complaint, again without moving to amend, that completely omits the contract or reference to helping timeshare owners, LLC, etc. I suggest to the court that further demonstrates there is no nexus or connection between the non-party entity and our plaintiff, as is currently alleged and as is before this court. Your Honors, if the appellant believed this to be an enforceable contract, which it realleged into every single count, it would have either filed for arbitration because of the arbitration clause, or at the very least, cited Florida law in the Tennessee complaint. No Florida law is cited in our complaint here, even though this contract, purported contract, has a choice of law provision. For these reasons, Your Honor, the appellee asks that you affirm the trial court. Thank you.
Let me ask you, Mr. Jackson, if there is no enforceable contract, is there a statute of limitations issue with regard to the tort claims?
Your Honor, I believe there would be for the civil conspiracy and perhaps for the breach of the duty of loyalty. It's something we argued before the trial court that trial court didn't get to, and perhaps would need to be renewed if this were to be remanded and before the trial court. But in my view, Your Honor, we don't get to that analysis unless and until there is some viable claim that remains for the defendant to then look at the statute of limitations. And again, without count 1, breach of contract, we have no counts because everything was incorporated and realleged together.
Did you raise a statute of limitations defense in your brief? Did you argue anything about that in your brief?
Not in the brief before this court, Your Honor. Your Honor, may I have additional time to respond briefly?
Sure. Yes.
Thank you. Not in the brief before this court, Your Honor, because as it stands, the trial court's order and judgment dismisses them all together as reliant upon the purported contract to the complaint. That would be certainly a defense we would raise if this was remanded and somehow 2 counts survive or separated from the other and 2 survive, but not in the brief before this court at this time, Your Honor.
Okay.
Thank you.
All right. Thank you, Mr. Jackson. We'll hear from Mr. Barrett in rebuttal.
Your Honor, 3 points in rebuttal. The first point is that counsel has talked a lot about how there's no nexus. The contract has no nexus between the defendant and the non-party entity that's a party to the contract. And if that's true, and that court, and if the court accepts that argument, then that contract cannot impact the employment relationship that we've alleged that we've alleged in other paragraphs in the complaint. The complaint has 3 or 4 different places where we expressly allege that plaintiff employed the defendant. So if this contract is not enforceable and there's no nexus and it's with this non-party entity that has nothing to do with the case that the plaintiff or that the defendant signed the contract with, then that allegation says nothing of the relationship with the employee, between the employment relationship between plaintiff and defendant. And I would just point out, when I was talking about the LLCs versus the incorporated, I wasn't making a representation about anything. I was citing that as an example of a situation in which you have another completely different case where a party comes in and they perhaps list the name of the entity with an LLP rather than an LLC, or an INC rather than an LLC. I don't think under those circumstances, a court would find that the agreement is totally unenforceable simply because you have a mutual mistake as to the name of the entity. Now, if the parties could present evidence that one party understood this to be an LLP and they were making some sort of determination based on the liability issues, that would be another thing. But as Mr. Jackson said, and as said in front of the trial court, this defendant had nothing to do with the Florida entity. She has no connection, no bearing, nothing to do with the Florida entity. And that is because it's merely a mutual mistake that she and the person who put this agreement in front of her, presumably, when they put the agreement in front of her, they didn't take a minute to look at helping timeshare owners versus help for timeshare owners and make sure that was the correct entity. And there was merely a mutual mistake. The contract is formed when the plaintiff and the defendant agree to an employment relationship and to the terms of the employment. The written instrument really merely reflects that agreement. And if that agreement has been inaccurately transcribed or recorded, then a court has the power to reform that agreement. And that's what we're suggesting should happen here. But again, going back to the duty of loyalty claim, the contract is completely independent of that claim, and whether or not it's enforceable is immaterial to that claim surviving. Thank you very much. Appreciate it.
Gentlemen, thank you very much for participating in this Zoom oral argument. Obviously, we will take this matter under advisement and render an opinion as quickly as we can. Thank you again. Ms. Kraft, anything we need to take up before we recess to the call of the next case?
No, Your Honor.
All right, you may recess court.
This Honorable Court of Tennessee is now in recess.
Thank you, gentlemen.
Thank you all.